All right, I'll get going on time. Welcome to Merthyr's first ever client webinar. So many of you before have come along to our seminars, face-to-face seminars, and this year, so we could fit it in with the busy schedules with budgets and everything going on, instead a series of webinars with different Merthyr law solicitors on different topics. So watch this space and there'll be more to come. All right, and those of you who've been to those seminars would also see that for at least about the last 5 years, my topic has typically been SMSF update. And it's not me saying the same thing over and over again. It's just that this area there's always so much happening. I've always got more than enough material to present. So as usual, there's been a lot of action in this space. Since my last seminar around a year ago, what's happened? Well, we've had a change of a change of policy, and also that also means a different outlook towards superannuation. So certainly with Malcolm Turnbull cabinet, certainly there's been suggestions that he wants to make the superannuation system fairer. And Tony Abbott had certainly said he'd make no adverse changes to the superannuation system during the first term of his government. And look, I think Malcolm Turnbull will stick to that, but certainly there's some big changes that have been announced. Where are we up to? I guess we've got the very novel situation, the first time it's happened in 40 years, both houses of parliament being prorogued or recalled by the Governor-General, and that commenced on Monday, and that was ostensibly for the Senate to debate and pass the ACCC bill, which would act as a trigger for a double dissolution election. And so that debate happened on Monday. It was a very short debate, and the Senate rejected it outright. And so now we're with the situation that the government is waiting until the budget date, which has been brought forward a week to May 3, for the government to make its budget. Then the budget reply speech of May 5, and then shortly after that, Malcolm Turnbull will head off to the Governor-General and call a double dissolution election on the 2nd of July. So look, I think what that really means is that this budget's not going to be legislated this financial year. This is an election budget. This is the platform for the coalition's policy that they'll be taking to an election. Therefore, in my opinion, that means that these changes, there won't be dramatic changes which take effect immediately this financial year. So for example, I know some people are getting worried about making their concessional contributions and making contributions before the budget date. But if you look at it logically, is the election, any budget would be conditional on the coalition winning the election. And that happens next financial year. So how can they stop contributions for the balance of this financial year? I just don't think it's plausible. Having said that, there might be some other changes that they backdate to the date of the announcement. So what are some of the things that people are doing in anticipation of these changes? Before I get onto that, sorry, the other announcement from the Turnbull government there's been a lot of looking into defining what superannuation, the purpose of superannuation, and the retirement system, including the paying of the age pension, should be. And although it's not formalised in a legislative instrument yet, should be used for not as a estate planning vehicle to pass wealth on to future generations, but instead it being used as a substitute or a supplement to the age pension. And you think about the age pension, it's not a lot of money. And so certainly the clients that we're used to dealing with self-managed super funds, they're certainly planning for a retirement on a much larger scale, and certainly for something to be left over in many a case for their children. And so really the purpose of super in this legislation is going against that and saying, well, it's really just as to take the pressure off the age pension system. And so thinking about that, what could that mean moving forward? Well, I guess on the one hand, it could be changes to the death benefits tax. So presently it's the taxable component of super, it's 15% plus the Medicare levy if superannuation death benefits are paid to adult children. Perhaps that'll be tinkered with, perhaps that'll be changed. Other areas that people are thinking might be changed are, well, lifetime contributions. So back to those reasonable benefit limit type of arrangements, or otherwise limiting the amount of money that can be put into super, whether via your concessional contribution caps or your non-concessional contribution caps. So there might be a lot of limiting. Reported that as a leak to the budget, that the Division 293 arrangements, which were instituted by Labor effective in, I think it was 2012, 2013 financial year, that was the additional 15% tax on those high income earners over $100,000 for their contributions over that amount. So the coalition government is set, according to these papers, to bring that amount down from $300,000 to $180,000, which is a substantially bigger drop than Labor government, which has suggested bringing that down to $250,000. And so effectively that means that there'll be people after a certain income bracket, after that $180,000 income bracket, if they're making those concessional superannuation contributions, well, they're paying an effective 30% tax rate rather than a 15% tax rate. This regime has caught many people by surprise. They get a surprise assessment from the Commissioner and they've got 21 days to pay it. It's also been a real headache for the larger funds to be able to administer. So that's going to become a much larger headache if those changes go ahead. As far as our clients, what are they doing? Well, as part of Turnbull's rationale, is he said, well, it's not really fair. We shouldn't affect existing pensioners, so people who are already in a tax-free pension, and we should be looking at making the system fairer moving forward. So therefore, people who are already in that retirement phase should consider, if the coalition government gets in, that their retirement planning is relatively safe. Some people consider, well, okay, why don't I start a pension now? So if there's any changes to that regime, I'm part of, my fund's got an eligible pension, and the grandfathering rules would apply to that. So some people are commencing transition to retirement income streams for that reason. And also, there's a chance that the transition to retirement income streams will, they might be taken away moving forward because that's one of those regimes which people are taking advantage for some tax arbitrage. However, the political advantage of that, the political cost of that versus the tax advantage, I probably don't think it's worth it, because that preservation age is increasing from 55 to 60 over the next few years. And therefore, people taking advantage of those trisses, it's not going to continue for too much longer. What else are people doing? I guess making those concessional contributions before the budget. As I said before, I don't think that's really necessary. Where you've got clients who really want to pump prime their super, that's traditionally been done by, we'll say, this financial year, so before June 30, making a contribution of non-concessional contribution of $180,000. And then next financial year, so July 2, making a non-concessional contribution of $540,000. So activating that bring forward rule to get $720,000 in over a month. So some people are saying, some people are putting in there $540,000 before the budget and giving away that opportunity to actually increase that to $720,000. Look, I don't think that's necessary. I think the budget might announce those changes next year. If the budget does do that, and we think the coalition government's going to get in, well, at that stage, people might decide to activate that bring forward rule and put in that $540,000. Now, having said that, though, I was in this very discussion with an accountant last week, and he reminded me that I don't have enough grey hairs yet to remember the old contribution surcharges tax. And so he was having this discussion with the client saying, oh, no, it'll be right. It won't come into next financial year. And it was brought in on the budget date. So, you know, he's certainly got a different opinion than I do in that regard. In light of those comments too, that superannuation shouldn't be used as an estate planning vehicle, but they don't want to affect existing people's planning that's already been put in place. There's more people doing those re-contribution strategies. So taking, who've met the condition of release, they're taking money out of super and putting it back in as an after-tax contribution to really reduce the taxable proportion of their super. So more of that going forward, with the concern that there's going to be a bit of tinkering with super. And then look, every year there's concern that the limited recourse borrowing rules for self-managed super funds might change. I don't think that'll happen in this budget, but typically some people think it might. And so they might want to have those arrangements in place before the budget announcement. Also, if there's tinkering with the generous small business capital gains tax concessions, a lot of clients and accountants will actually make sure that if they're getting, say, commercial premises into a self-managed super fund, so they can take advantage of those small business concessions, they want to have that contract signed before the budget date. And it might be subject to finance or subject to some conditions so they can get out of it. But so then they're not caught if there's any adverse announcements in the budget. So every year we get a few people doing that. As I said, if you've got any questions, just type in that chat box as we go through. All right, moving on to limited recourse borrowing arrangements. So the Murray Financial Services Inquiry, all of its recommendations were adopted or accepted by the government, except for the one that self-managed super funds should be banned from borrowing. So I think that means that at least for the next couple of years, limited recourse borrowing arrangements are here to stay. There was a lot of talk about related party arrangements, and I'll get to that soon. I think, you know, that's more of an ATO issue, is how it's being dealt with, rather than a legislative issue. What is happening though is there's more and more supervision by APRA, and more. So they're really leaning on the banks for what their lendings are. They're not growing their investor book by too long. You know, being very prudent in lending to self-managed super funds and lending to investors. They're keeping a close eye on risks to the property market and risks to the banking system. And so you've seen that several banks have dropped out of the self-managed super fund lending space, and a lot of banks have changed their rules and requirements and you know, what they'll accept. So I think APRA is playing a role in reducing the amount of new self-managed super fund borrowings that are actually occurring by leaning on those banks. The ATOs had us a look at LRBAs and actually looking out for those property spruikers who are really preying on the more uneducated or more innocent superannuants, getting them into dodgy investments and spruiking some schemes that they might not be licensed to spruik. And so then they're reporting them onto ASIC for ASIC to take some action in that regard. So the space is changing, but I don't see any legislative change on that for the next at least 2 years, in my opinion, although I don't have that crystal ball. Look through legislation for these instalment warrants and limited recourse borrowing arrangements. It was first announced in 2010, and finally, some 5 years later, in September last year, we got that legislation through Parliament. And so that the effect of that is that for tax purposes, the superannuation fund is treated as the owner of the asset. And that's good news, because there was a couple of financiers, a couple of banks where there's documentation was set up that it could be a technical capital gains tax event on the repaying of the loan. So we used to have to give that warning. Now with this legislation, it's made changes to the Income Tax Assessment Act. With that legislation through, well, our advice has gotten significantly simpler, and we don't have to give those warnings anymore. So that's good news. It took us a long time to get there. The big space for limited recourse borrowing arrangements, and I talked about this last year, was related party loans for these limited recourse borrowing arrangements, and especially whether they were on arm's length terms, and therefore, if they weren't, could there be non-arm's length income tax issues? So the income derived from that arrangement being taxed instead of at 15% or 0% being taxed at the top marginal tax rate. Last year I talked about ID 2014-39 and 2014-40. They've been replaced with these ones here, 28 and 2015-28, 2015-27. I'm not sure why exactly they were replaced. I think it must be because this looked through legislation and it was enacted in the meantime. But they're essentially on those same terms. And just as a reminder, for the commercial property, the one in that ATOID was, it was an 80% loan to value ratio and a 0% interest rate. And it was principal and interest being repaid over a period of 15 years. ATO said that arrangement actually constituted a scheme where the superannuation fund wouldn't have been able to have those terms, had gone to an arm's length lender or done it on an arm's length basis, and therefore wouldn't have made the investment. So they considered that the income derived from that would have been non-arm's length income and taxable at the top marginal tax rate. After that, the ATO, after those IDs, the ATO said, hey, if you get your house in order by 30 June 2016, so this year, say the loan is consistent with an arm's length dealing, having a look at all of those factors, the repayment terms, the loan to value ratio, the interest rate, will then, administratively speaking, we won't go and try to amend assessments for prior income years. Which is good news, because I guess as a non-arm's, then it's hard to fix that up in a subsequent income year. It was non-arm's in that year and it could be tarnished forever moving forward. What the industry has been waiting for, though, is, well, these IDs, 1% interest rate, what does the ATO consider to be consistent with an arm's length arrangement? And that's where it was only, 2 weeks ago, the ATO brought out these safe harbour guidelines that I'll walk through soon, so the ATO would consider to be consistent with an arm's length dealing. Just before I go to that, I've just pointed out there's a couple of private rulings that have happened in the last year that are of interest. This first one here, this 606, was a party mezzanine finance arrangement. So under this one, it was the superannuation fund had a loan set up with a arm's length lender, and they'd said, oh, if it goes over this LVR rates, you know, the additional interest rate that we'd consider charging will be whatever X points above the standard variable rate. So with that, they actually did up a related party mezzanine loan, and did that above the same kind of terms that the bank had offered. And so they put that to the commissioner. It wasn't non-arm's length income, so it was consistent with an arm's length dealing. So even on that mezzanine finance kind of basis, they managed to pass that test. This next one, the 4259, was a loan to a company. Sorry, this was one, it was a peculiar arrangement, and it was where the self-managed super fund subscribed to $1,000 worth of shares in a company, and another entity also subscribed for the same amount of shares. The commissioner considered, well, I guess that was the market value of the shares, because, you know, they'll pay for cash and the company owned nothing. Then it was proposed, though, the company go out and buy a business, and it borrows 100% of that business from a related party lender, and that be done on the standard residential rate. And the ATO said, look, putting all those things together, that's a scheme that the super fund wouldn't have entered into but for this loan that was essentially not consistent dealing, because there'd be no lender out there that would lend 100% to an equivalent arrangement. And so the ATO considered, well, if there is any income derived from that structure, that will be considered non-arm's length income of the superannuation fund, which I think kind of makes sense. And just one last kind of development with the limited recourse borrowing arrangements is the regulations were changed to say that insurance could only be held by a fund in the name of a member. And so the ATO is of the opinion that means you can't, fund trustee can't, or a fund trustee can't involve itself in cross insurance arrangements. So where one member's account owns a policy on the other member, which was great planning from a limited recourse borrowing arrangement perspective. Although there's arguments against the ATO's opinion, they've said it time and time again, they're not budging there. So unless you want to have that big fight with them, I think we're stuck with the ATO's reasoning there. All right, so what are these safe harbors? There was 2 lots issued, one for real property and one for investing in shares. We don't really have many investments in shares come across our desk, so I'm just going to focus on the real property. And that was a interest rate of the interest rate for these guidelines is the RBA indicator lending rate, variable for housing loans for investors. Quite a mouthful. Send me an email if you want a link to where that variable rate, you can find that on the internet. And what that was for this financial year, so what the rate was in May 2015 is 5.75%. So effectively, that interest rate is reset under these loan agreements on 1 July each year based on the prior May's indicator rate. Now, the term of the loan has to be 15 years, and with any refinancing to be limited to an overall 15-year loan term. So that's of interest. Let's say in the examples, let's say if the related party loan had been set up in 2011, then we refinance it to meet these safe harbour guidelines this year. Well, as it's already been running for 4 or 5 years, or we'll say 5 years, then the balance loan term can only be 10 years. So it goes from when that loan commenced. Loan to value ratio is 70%, and that's considered when the loan's taken out or when the property is acquired, or when we're redoing them for existing loans. We're looking at 1 July 2015 as to what the value of the property is on that day. The loans need to be secured by a registered mortgage. Personal guarantees aren't required. Now, this is the clincher though. Interest only is not allowed. There has to be monthly repayments on a principal and interest basis. So it's got to extinguish that loan over the term. And that's despite there's many deals that I see all the time, 3 and 5 year terms from banks that are on an interest only basis for that initial 3 or 5 years, and then they revert to P&R. The loan agreement has to be written, it has to be signed. It can't be minutes, it can't be oral. And I forgot to mention, with that interest rate, that can be fixed for a period of up to 5 years. After then, to go to the variable rate. The safe harbour loan terms for related LRBAs. So what's the legal effect of these? So what it is, it's not a taxation ruling. What it is it's an administrative statement from the ATO saying, hey, if you've got a loan equivalent to these terms, then we won't make any further investigations and we'll consider that on face value. And administratively speaking, we won't look what went on in prior income years. It says from an audit risk perspective, we won't give any further thought to people who meet these guidelines. What it is, party loans must meet these safe harbour guidelines. It's not like Division 7A. This isn't legislation at all. This is the ATO's interpretation of the non-arm's length income rules. And this is the ATO, even in these safe harbour guidelines, just say this is one method that we consider to be consistent with an arm's length dealing. The ATO says itself, even you'd meet these guidelines if you had evidence from a bank or an arm's length lender. So that's a particular, so then if, let's say, if a client did want to have an interest-only term, because really a lot of our clients, it would massively affect them having to do P&I rather than interest-only. So what I'd recommend there is, well, hey, get some contemporary evidence of what's available out there, and even better if it's available to you, best case scenario, a letter of offer, but at least some evidence out there that you'd meet this lender's criteria for them to lend to you, and this is what the rates that they offer. So you keep that on file, and I think it'll be a pretty short conversation with the ATO. Practically speaking, a lot of people get busted for non-arm's length income in these arrangements. And I think it's pretty simple. On the superannuation fund, self-managed super fund tax return, there's a box there that says liabilities, and that needs to be filled out. So that would indicate a limited recourse borrowing arrangement. There's also a deduction box there for interest deductions. So if you had a $500,000 liability and 0 interest deductions, well, that'd be that red flag for the ATO to say, okay, well, that's on a 0. They would be the ones that the ATO would put at the top of their audit list. And I submit that those ones that have made no attempt to try to charge a commercial interest rate, they're the ones the ATOs will be going after and to make non-arm's length income assessments on. In those cases, they'll be back to prior years, and they'll be assessing it for the 2014 year, 2010 year. And because it hasn't been self-disclosed and there's been this publicity about it, there'll be that potential that they'll also seek penalties and interest on those. Do the safe harbour guidelines apply to instalment contracts as well? Well, it hasn't been considered in these safe harbour loan terms. It's just not a consideration. It's just dealing with these LRBA arrangements. From a broader perspective, though, non-arm's length income does have to be considered in those structures. So they do need to be as if they're on arm's length terms. Otherwise, there might be an advantage to the super fund. I hope that answers the question, Tanya. So look, what we're recommending is really give yourself that safety from those prior years. Give yourself that safety from the risk of the ATO making a non-arm's length income assessment. Try to get your loan, if not on these safe harbour terms, at least refinance that loan, have a look at it, and get it on a position that's supportable from some temporary evidence of what's available from the banks, etc. What can we do to do that? Well, we vary that loan to meet those safe harbour terms. Base the date for valuing property on 1/2015. And then, well, the ATO is saying if you want to meet those safe harbour guidelines and meet that 70% LVR, well, really, if the LVR is greater than that, well, you should be repaying sufficient principal under that loan before 30 June this year to get it within a reasonable loan to value ratio requirement. They're also saying if you want to get the protection from them not looking into prior years, there's got to be the principal and interest paid for this financial year. So that would cover the whole financial year, even if we've back-ended those payments so they all happen in June. But we've really got to meet principal, or at least meet those consistent with an arm's length loan terms for this financial year. And that should give us some safety under the safe harbour guidelines from the ATO investigating prior years. So we're certainly saying, I'm going through trying to put a list of loans that we've done clients, but certainly if you've got clients who've got these type of loans, it's worth considering them, and worth considering them soon while we've still got this ability to fix these things up before 30 June. I think certainly the highest risk clients are those ones who have got an under market interest rate or 0 interest rate. I think they're definitely going to be in the ATO's sights. And I think the ATO will be coming after them. So I think those ones should really be looking at getting onto these safe harbour guidelines, or at least getting that evidence of contemporary or what lenders would lend to them, and making sure that their loan complies with that. Because that, hopefully, if the ATO adheres to their own audit guidelines, should mean that they're protected from the ATO investigating prior years. Otherwise, they've got significant tax risk moving forward. Another spot to watch out for, I guess, these safe harbour guidelines don't mention loans which are used to acquire units in unit trusts or shares in companies. And we've done a fair bit of that with, some novel property development structures, etc. And there's not many financial institutions that lend to those types of structures, your ungeared unit trusts and those types of things. So I think we need to be careful with those and have a good think about those and work together to make sure we've got an argument that whatever loan applies there is consistent with an arm's length dealing, and certainly that a commercial interest rate is being charged, and that might be a bit higher than an interest rate where there's a mortgage over real property. The ATO's compliance, this based on a speech by the Assistant Commissioner last year. What they're looking at is related party contribution or transactions that are essentially used to avoid contribution caps, so unvalued transactions, etc. These dividend stripping arrangements, I'll talk about those in a second in the next slide. Property spruikers for LRBAs, stuffing up the entities, etc. on those LRBAs. An interesting one, extraordinary or out of pattern growth in the SMSF asset value. So if suddenly being revalued and it's not in line, consistent with the history of the fund, well, that's a red flag to the ATO. Is something funny going on there? Or they're trying to be smart? And even having the proper valuation evidence, it could be, if it was a real anomaly, the ATO might be making some further investigations. What was the real reason that these assets have changed in value so much? Has something untoward gone on? Pensions, having a close look at those pensions, meeting the minimum pension payments, and a lot of experienced taxpayers are getting caught out here, and it's an expensive mistake if you don't meet those minimum pension payments. Also, making sure that when you're valuing what the pension assets are worth on that 1 July, it's market value, it's not historical cost value. So cost value, there's that risk that the ATO could say, well, that's not right, and the minimum pension payments weren't met. Continuing that focus on those early access schemes, and also your in-specie payments under pensions to meet minimum pension payments. They say you can actually do that where it's a partial commutation, but you've got to get your paperwork right at the time. And so if you don't do it right, well, you haven't met those rules and you might not meet the minimum pension payments, etc. And there might be other tax consequences for the fund. All right, one strategy in the last year that's been doing the rounds, and the commissioners actually issued quite a few private binding rulings on this, is making lump sum payments under these transition to retirement income streams, these TRISs. Before I get there, let's just have a look, I guess, for those who've reached the preservation age but haven't yet reached 60, so it's still taxable, what comes out of their superannuation. They can always, in that period, pay out their unrestricted non-preserved benefits. And if they pay that out as a lump sum, then they get the advantage of the low tax rate cap, which I think is $195,000 for this financial year. So essentially they can pay out $195,000 as a lump sum to themselves tax-free. Alternatively, if they did that via a pension, well, then it would be at their marginal tax rates less a 15% rebate. Now, typically with transition to retirement income streams, that hasn't been done. It's all been received as a pension. There's a really good paper, and it was Mark Elam who I think was originally advising on this strategy. So look that one up, where in these pensions, if you've got those unrestricted non-preserved benefit, well, then you can make an election to treat the payment as a lump sum rather than as a pension payment. So it's a partial commutation of that pension. There's rulings that say, well, that meets the minimum pension payment for the year, but then it also gives you access to that low rate cap amount. So you're not paying any tax on the drawings from that pension. And even better than that, with these unrestricted non-preserved benefits, well, it's possible you can even go over that 10% maximum, which is under those tristles. So quite an interesting strategy there. The ATO is also, aware of this, and again, they've said it's quite complicated. There's a lot of areas you can fall down on. If you don't do it right, I'd recommend you get private bind ruling, so you're in that safety area. Last year, I talked about the strategy of deliberately. I talked about the strategy where finally they brought in the refund regime for excess contributions, rather than being subjected to the penalty tax of up to 93%. So we talked about this strategy that you could deliberately exceed the non-concessional contribution caps, because then when you get the notice to take money out of super, you could take it out of, I think that was 100% taxable. So that was a method to really increase the non-taxable component of your super. The commissioner, just in conversation at one of these industry meetings, has said, well, we might consider applying Part 4A to such an arrangement. So again, just be careful of that, and perhaps private rulings, or just be careful in that's Part 4A. Of course, it's been on the cards for a long time, the changes to these collectible rules. So, keeping your cuckoo clocks and your motor vehicles and your paintings and those types of things inside your superannuation fund. Those rules changed in, I think, 2011, 2012 for new assets, but there was those grandfathering rules for those assets that were already in there. The grandfathering period ends this June. So our clients have either got to get those assets outside of that super environment or comply with those rules, i.e. your storage requirements and your insurance requirements, etc. So not much time to get the house in order there. Of course, those superstream compatibility requirements for self-managed super funds receiving contributions from non-related employers, they've got to be up to speed on that now. They've got to have that electronic identification and be able to receive those funds electronically. I talked before about these dividend stripping arrangements, and so there was about 4 or 5 private rulings that went through the tax office where they go on for about a page and a half of the asset protection and the estate planning rationale behind why they were doing this. And what it was essentially is that the superannuation fund would buy shares in a related private company that had significant retained profits, that have the big rationale for it. Typically, this super fund would be in pension phase, and so then after the transaction has gone ahead, then the company would declare a dividend of all of its franking credits, and the super fund would get a refund of those franking credits back, so a significant tax saving. The ATO has put out this taxpayer alert and said, well, despite these 4 or 5 private rulings, that isn't an administrative practice of the commissioner, and we will be seeking to apply Part 4A or the dividend stripping rules to these types of arrangements usually, and some public guidance, i.e. a ruling or ATOIDs should be issued soon. So I guess if you're looking at any acquisition of super funds of related party shares, obviously watch those acquisition rules in section 66. There's lots of exceptions to those, but also will be careful that the commissioner might intend to apply the dividend stripping rules or Part 4A to it. So you might want to get a ruling before you do anything like that, because otherwise it's an aggressive tax planning area that the commissioner is keeping a close eye on, and you get these taxpayer alerts, and so that can mean some penalties can apply if you still go ahead with this strategy without those private rules. As I said before, hey, it's not 55, the preservation age anymore. And we make that mistake and we start paying a tryst to someone who hasn't met the preservation age. Well, the accountant's in trouble. The client's going to go after them for any losses they suffer because of that. So keep it up on your wall and try not to make that mistake. Or I'm sure some software packages don't let you start pensions anymore if the person hasn't met that preservation age. All right, estate planning. I am intending on actually doing a bit of a video up of what I've talked about over the last few years. So the different superannuation fund estate planning cases, binding dominations, all of those concerns. It's a real hotbed of activity. And so if you follow us on YouTube, when I put that up, you'll get notification of that. What's happened in the last year, the main case of interest is this Brian and Carter. And so I'll just quickly refresh your memory or explain to those who didn't see me last year the case of McIntosh and McIntosh. And in that case, it was the mother and father's son died. The mother and father had been divorced for some years. The son lived with the mum, I think he was about 30, and didn't have a will. And so his main asset really was those insurance policies with the big super fund. So mum and dad divorced, they couldn't get along at all. So one of them, it was more appropriate that only one of them applied for letters of administration. Otherwise, nothing will be agreed upon in the estate. So the mum applied for those letters of administration. After she'd applied for those, she actually then went around to the different super funds and sought payment from those super funds to herself personally. As she said, well, she was in an interdependency relationship with the son. And Justice Atkinson found that, well, as an administrator, she had a duty to, as an administrator, to maximise the value of the estate. Therefore, those insurance policies that she had, were held for the benefit of the estate, so half for the dad, and I think she had some cost orders against her too. Commentators since then, and Justice Atkinson said, well, you know, there is a difference between an executor who's named in the winter by the testator, so, you know, they don't get a choice of, you know, being nominated for this role, versus an administrator who actually applies to the court to take on this role. And so he also said, look, there's certain circumstances where a conflict of interest might be consented to. And he gave the example of where a testator appoints an executor who's also owed money from the estate. Well, that's consenting to that person seeking the repayment of their debt, even though they're in a conflict position as executor. I guess another example, he didn't really say this, was when you appoint an executor who's also a beneficiary. They've got those two different roles on there, a beneficiary and an executor. That's kind of different because it's the executor who appointed that. So a lot of people are saying, oh, well, maybe McIntosh and McIntosh won't apply to circumstances where there's a will in place and the executor's appointed. And so Bryan and Carter has put that question to bed and has said, well, no, the same duties apply. So what are those? Have a quick look at what the facts of that case were. And so in that, the deceased member with UniSuper had two pension accounts. One was one of these indexed pension annuity benefits, where the spouse was the only eligible recipient. I think she had received 70% of his payments for the balance of her life. So there's no residual capital component. The other pension was a flexi pension, and that one did have this lump sum benefit of $545,000. The deceased member had made a for him to pay his super benefits to his estate. And his will appointed the second wife, who was a beneficiary of that index pension, as a co-executor along with his three sons from a former marriage. And so the wife then, what she did is she failed to disclose to the sons, the other executors, that they could have actually made a claim for this $545,000 pension. She said, oh, no, it's only dependents who can receive that. And dependents are spouse or infant children. And so that was wrong. I don't know if it was deliberately wrong or she just didn't understand the actual deed. But regardless, the sons ended up asking their own questions. And then she disclosed the true nature of that pension from the 4th of March. She'd made her own claims to UniSuper, before then for the payment of the benefits. But then the sons all made a claim to UniSuper for the payment of those benefits. And UniSuper didn't make its decision until June. So even though the mum didn't do the second wife, didn't do the proper disclosure, it didn't affect UniSuper's decision. And you look at these retail and industry funds, and their predisposition and that of the Superannuation Complaints Tribunal is where there's no binding nomination to pay the super benefits to a dependent, so a spouse or an infant child. And they even say that on the Superannuation Complaints Tribunal website. So anyway, the fund trustee acknowledged the non-binding nomination, but still proceeded to pay that pension to the second wife. So the judge in that case, Justice Blue, found the wife to fiduciary duty as executor for applying for both pensions. He said, look, what she should have done if she wanted to do that is she should have not accepted her appointment as executor, and the sons then could have made that application. Then she would have had no duties to the estate, and she wouldn't have had a duty to disclose to them what the true nature of that pension was. Alternatively, she could have sought their consent for the conflict, and providing it was informed consent, that might have been sufficient, but she would have had to give full disclosure of what the nature of those pensions were. But she didn't do that, so she was in breach of her duty as an executor. And Justice Blue said, well, the same duties apply to an administrator as an executor. So it developed or reconciled McIntosh and McIntosh. Justice Blue found the wife had breached her fiduciary duty as executor by not disclosing the true nature of that pension until 4th of March. But as it didn't have any influence on the outcome of UniSuper's decision, he didn't say that that the second wife held any of those monies that were paid to her on account for the estate and for the children from that first marriage. Where His Honour, I think, gave a little bit of consideration to those breach of fiduciary duties was, I think he didn't make as harsh a cost order against the sons as would otherwise be the case. Usually costs follow the cause. So look, it's interesting. This is a really developing area of the law for superannuation disputes. I think your binding death benefit nominations and the technicalities of those are reasonably well settled with Katz and Grossman, Donovan and Donovan, Iapolo and Conti. It's these, what are the duties of executors? What are their fiduciary duties? And also with the self-managed super fund, we're looking at what are the fiduciary duties of the actual trustee? And often the executor and the trustee, well, the trustee is the decision maker who actually makes that decision of who to pay those benefits to. So this is the real developing area. And the one that I think is particularly of interest is where you might even have a husband gives his entire estate to his second wife, appoints her as executor under the will, and then the wife would take over the super fund too. Now, that wife's executor, and then his kids from prior marriage make a family provision claim over the estate. What are that wife's duties then? How does she reconcile the conflict of executor and her as, the trustee of that self-managed super fund, making that decision to pay those benefits to herself rather than to the estate? Is there a consent to that conflict? Because he said, oh, well, my wife's the sole beneficiary under the will. Whereas an executor's got a duty not just to the named beneficiaries, but also to any people who haven't been adequately provided for and make a family provision claim. So I think that's a fertile area, and I think there'll probably be a decision on that in due course. I'll answer these other questions just when I finish this last case study, and apologize over time. Daffy and Daisy are co-directors and equal shareholders of Looney Tunes, SMSF Pty Ltd, and that is the company that's trustee of their self-managed super fund. Daffy dies. Daffy's will leaves his super to his children from his Elmer and Yosemite Sam, and appoints Daisy as his executor. Daisy comes to see us, saying, what can she do to keep Daffy's superannuation? So in this case, of course, our first request would be, hey, well, can you give us a constitution of Looney Tunes SMSF Pty Ltd and give us a copy of the super fund deed? Now, the super fund deed, if it doesn't allow one member's legal personal representative to change the trustee, well then, if it's a typical company, Daisy is executor for the estate. Well, the legal personal representative doesn't have enough shares to force a shareholders meeting to appoint themselves as director. So in that case, Daisy's best action would be to actually renounce her appointment as executor, let the kids, Porky, Elmer and Yosemite, take on that role. And in that case, they wouldn't ever get the votes to actually appoint themselves as a co-director of the super fund. Then Iapolo and Conti, and there's other cases which would validate then that Daisy as that director, as long as she considered all beneficiaries would be entitled to pay Daffy's super benefits to herself. So I hope that makes sense. It all depends on the deed, etc., of course. Now, how does this advice change if Daisy wasn't a member of the self-managed super fund or that corporate trustee? So it was just Daffy was the sole director and member. Well, in that case, I guess she doesn't automatically. She's not a director of that company, so she's not already on there. So the executor of the estate would then appoint themselves through a shareholders meeting to be executor. Now, in this case, if it was Daisy herself, well, she'd appoint herself as director, and then if she was doing that with then the intention to distribute all that super money to herself, she's probably breaching that executor's duty, even though that conflict transaction's allowed under that super fund deed. So I think that could get challenged. An interesting one is too, what if it was Daisy that was executor alongside the 3 boys? In that case, well, executors have to act jointly, but they can't because Daisy's got a different view than 3 boys. So then I guess under your normal replaceable rules and constitutions, they say, well, when a joint shareholder can't have a unified vote, well, then they'll take whoever's first mentioned in the register. So that could well be the first executor. Having said that, even if legally that's the case, equity would still prevail to say, well, in exercising that role as an executor and as a shareholder, it's got to be done under that fiduciary capacity as an executor. So I don't think Daisy could use that technicality to then go and distribute all the super to herself, or I think it would be subject to challenge if she did. So look, and as I said before, I think the really interesting case is what if Daisy was actually appointed as the sole executor for Daffy and under the will be entitled to a super fund? But in that instance, Porky, Elmer and Yosemite then made a family provision claim against the estate. I think there's arguments either way, and I think that's a hot topic for further judicial interpretation. Around that, so I'll just answer these outstanding questions. Is that article with respect to paying lump sums under transition to retirement income streams? That was written by Mark Allen of Super Concepts. I'll just try typing that in to the answers. And Peter Dawson has asked, can an investment debt incurred by the super fund be transferred, sold to an associated entity, thereby effectively transferring a loss out of the super fund? I've looked at this before when we're trying to actually wind up super funds, and we go, well, the super fund made an investment that was worth $1 million, and it might have been a prohibited loan or something like that, but the loan's not recoverable, so it's only worth $1 now. So we actually transfer it out at its market value. And I think that's got some legs. However, the ATO, you're at their beck and call of what penalty they'll put on you, and so you've got to work with them, and they don't like that sometimes. But that's a bit more involved. We can have a chat another time about that, Peter, I guess. Any other questions? Say them now. Moving forward, to keep up to date with what we're doing, we might not annoy you with emails all the time. We'll upload things from YouTube from time to time, and then follow us on YouTube so you get them in real time rather than we can get around to sending an email out. Follow our Merthyr Law or my LinkedIn profile, and you'll see what's going on with Merthyr Law and what presentations we're doing. And we've got a few more presentations coming up from Steve Grant on early inheritances and loans to the kids, Tom Walrut on some capital gains tax change, and we've also got Peter Pavusa telling us the latest in family law. So there'll be emails coming out about what those times are soon. So stay tuned for those. But thank you so much for being part of the first seminar, and I've gone over about twice the time of what I should have, so apologies for anyone there. We should have a recording of this, which we hope to send out in the next week or two, so you can forward that on. So thank you everyone for being a part of it, and give us a call if you want to have a chat or get those limited recourse borrowing arrangements into order. Thank you.